like I say, my name is Pearce and I work for Kevin Company in Belfast, and most of my work would deal with judicial review applications. For those of you who don't know what that is, it's basically legal challenges against public bodies, and one of which is the prison service. Now, I'd say approximately 50 to 60% of the judicial review work that we do is against the prison service. And I think the reason for that is really that when it comes to the prison service and prisoners, they take a very uncomplicated view of prisoners' rights and entitlements, which is why I think we end up in court so often challenging the Northern Ireland Prison Service. Kevin started off the talk tonight and he explained the situation that he was involved in back in 2002. And I worked along with Kevin then and a number of other prisoners who at that time were striving to be separated within the prison. And Kevin has already outlined the circumstances and the risks that were there every day for every Republican prisoner, many of whom were seriously assaulted. And of course, Kevin's already explained the difficulties that their family had and intimidation and stuff like that. Now, at that time, we were trying to see as many Republican prisoners every day, and we were trying to see as many as possible. And I suppose it began really when the prison service began to restrict and frustrate their access to us and our access to them. This would have coincided, of course, with the escalation of the protest that Kevin has already referred to. And once the dirty protest began, then the prison service sort of stepped it up a notch and it became virtually impossible to get to see your clients in prison. And of course that's very important for us and it's very important for the prisoners to know that they can have access to us so that we can try to address whatever concerns they have, whether it be through the courts or through correspondence or any other contact. So it was vitally important for us to be able to see them. What we were trying to do at that time was to call maybe 10 or 12 down at a time. And it was clearly the prison service knew that that was an opportunity for them to speak with each other and to discuss tactically whatever they wanted to do within the prison. Clearly they knew that that was what was happening, although we were just basically trying to see our clients. What was happening, what happened then was that they began to charge the prisoners with offences against prison discipline, which meant that they were brought to the board's punishment unit, to be brought in front of a governor, to be dealt with through the adjudication process, which meant that they could be brought down to legal visits. Also, while the protest was going on, they were forcing them to clean their own cells. Clearly, the only reason for that was that it was punitive, really. It was to punish them and degrade them. And because of that, then it led to them being placed in a position where they were basically being denied their legal visits and their family visits. So we were forced, really, well not forced, we had no other option but to challenge us through the High Court. And we took a judicial review, and we took that challenge on an emergency basis. I think it was summer months back in 2002, and we convened the court on an emergency. And we took that application on behalf of 12 separate prisoners. Some of you are in the room tonight. Kevin's obviously one of them. Terry McCafferty, John Connolly, and a number of others who were all similarly affected by this. At that time, as I say, the conditions were, I suppose, as they are now, and the conditions of detention weren't changed, and the basis for the legal challenge are the same as they are now. But we took that into court, and initially we got a receptive enough hearing from the judge, who granted us leave and gave us permission to take the case to the next stage, and it was listed within a week or 2 weeks for a hearing. Then clearly a decision was taken that the case should be dealt with in a certain way, and the Lord Chief Justice at the time, Lord Chief Justice Carswell, was appointed to hear the case. So we kind of took a view that there wasn't going to be a successful outcome of the case, which there wasn't. The judge concluded at the time that it was perfectly reasonable in the circumstances that the prison service could restrict and in certain cases deny access to legal visits and family visits. Because they were in protest, and at that time the judgment really was just shrouded in health and safety language. That's all it was. There was no legal basis for it, really. There was no finding against them on the law or for it on the law. It was simply based on health and safety, which I think at the time was a get-out. We appealed that decision, and we took it to the Court of Appeal, but by the time it was listed for hearing, I think the protest had came to an end because segregation had been put in place. and obviously the steel recommendations were accepted by the prisoners. So clearly there was a major step forward in terms of the prisoners getting their own wings, if for no other reason, just for pure protection really, because I think their lives were at threat on a daily basis. So, as I say, the conditions at that time were quite dire and drastic, and as I say, that was just one circumstance in which we had to take the case into court and deal with it on an emergency basis. And we've had similar experiences since then. When the segregation first was put in place, the prisoners who were on the segregated landings were asked to sign almost a contract with the prison service. It was referred to as the compact, and that compact basically set out times when they would be locked, unlocked, when they would get their meals, when they would get association, when they would get exercise, so on and so on. So basically what it was a diary of times that would set out the regime that you could expect if you were on the separated landings. Now, I don't think any of the prisoners signed that, but notwithstanding that, it was in place anyway, albeit for a very, very short time. And immediately that was reneged on. And of course, 23-hour lockup returned very, very quickly. The strip searching, I think, increased probably at that time. The rub-down searching increased, and basically the entire emphasis throughout that prison regime was on control. And I remember dealing with it at the time, and I worked with Kevin on this case also, and another prisoner, Patrick Leonard. Any of the letters that we wrote to the prison, and any of the replies we got, they simply made the same point every time, that there was no return to mainstay segregation. And I think that was always uppermost in their mind, so there was clearly an emphasis on security, and really prisoners' rights, or anything that was outlined in the compact, would be secondary to that. So again, having worked with Kevin and Patrick on this, Patrick Leonard did it, there was quite a bit of detail in that, and Kevin might remember this. This involved almost a root and branch review of the entire regime. At that time, I think prisoners who would have come down, for example, on a legal visit, would have had a rub-down search on at least 6 or 8 occasions, and would be strip searched maybe on the way to and on the way back from a legal visit, where they would have had no contact with anyone other than the prison staff and perhaps myself or one of my colleagues. And this continued, and it increased, and clearly what had happened at that time was all of the prisoners who, and I think the numbers were maybe about 25 to 30 on the lands at the time, got involved in what the prison service referred to as an orchestrated campaign of complaints. And I think from the prisoner's point of view, they decided to work within the system and deal through the system by complaining about the prison regime. But obviously that was held to their disadvantage when it came to trying to deal with these issues. Again, without going into all the detail, because that was quite a lengthy process, Kevin, and by the time we came to do something about it, I think Kevin obviously had been released from custody and had been acquitted on the offences for which he was being held. We took the case obviously in the name of Patrick Leonard. That case took an awful long time to come to hearing, and again it dealt with, as I say, the minutiae of the prison regime that was in place. Lock-up times, meal times, and basically just the prison staff on the wing, the controlled movement. Sorry, I haven't mentioned that. That was another major issue. The controlled movement and the strip search were the two main issues. But over and above that, there was just the basic daily regime: going to wash clothes, going to get your food, going to get your tuck shop. All of that on each and every occasion was frustrating. So that application took an awful long time to get up and running, and it went before the courts. And again, unfortunately, the courts refused that application as well. But throughout the time that it was running, I know the regime did loosen up a bit, and they weren't as focused on the strip searching or the controlled movement. It did relax. It was relaxed to some extent, albeit not as much, I'm sure, as the prison.